Can a trust protect your assets during a divorce? Well, in most cases, yes, but it depends upon whose divorce you're talking about. Hi, my name is Ladia, and I am a retired licensed financial professional with over 40 years within the financial services industry, including helping families navigate through distribution options, through trust accounts, through estate distributions, all to help them to understand everything much better. And that's what I want to bring to you today is my expertise in helping to make some of these things much more easier for you to understand and to help you and your family to have meaningful conversations with your attorney. Today, what I want to do is to separate fact from fiction when it comes to inheritance, trust, and divorce. During my career, I would hear clients say, hey, I'm getting married. I'm going to put everything in a trust so that when I divorce, my spouse won't have access to those funds. Well, unfortunately, that's not always the case. A trust is not a magic shield. It actually depends upon state law, when the trust was written and funded, if there are any marital assets involved, and who actually controls the trust. And that's why the better question isn't, can my trust protect me during a divorce? But it is actually, can a trust protect my grandchildren or my children during a divorce? And that's what we're going to look at today. Let's look at these two families as an example. Family A, the son inherits a large amount of money outright. He invests that money into his own account, and then years later he divorces. Well, those assets can become part of the settlement during the divorce. For family B, instead of them getting the inheritance outright, it is put into a properly drafted trust. The distributions are made by the trustee, and the beneficiaries benefit from the distributions, but they don't own those assets outright. And that can make a huge difference in how a family's legacy is protected. One of the benefits of an irrevocable trust is that the assets remain in the trust. Instead of the assets becoming the immediate property of the beneficiary, the trust continues to own the assets. Most trusts include what's called a spendthrift provision. A spendthrift provision is designed to help protect assets in the trust from creditors and, in many cases, claims during a beneficiary's divorce. But still, that's not absolute. It really depends upon how the trust is written, and that state laws vary from state to state. The trustees' actions matter, the beneficiaries' actions matter. And that's why so many attorneys take so much time to draft your trust document to make sure that it is designed the way that you want it to work for you and for your family. Even the best trust isn't bulletproof. Protection can be reduced if the beneficiary has access to the funds, if it is a poorly written document, if the state does not recognize the provisions within the document. And that's one of the reasons why having a do-it-yourself trust document may not be the wisest thing for your estate plan. As I mentioned earlier, the trustee's actions matter. Let me explain why. A trust is only as effective as it's administered. If the trustee follows the terms of the trust and acts independently, it reinforces that the trust, not the beneficiary, controls the assets. However, on the other hand, if the trustee ignores the trust document and routinely distributes assets to the beneficiary or allows the beneficiary to effectively control the trust, that undermines the intended purpose for the trust. And in some situations, that becomes relevant should the trust be scrutinized in litigation and including divorce. When people hear the word trust, they think about avoiding probate. And that is certainly one of the reasons why people create a trust. But there are also families that use a trust to help protect wealth across generations, not just from probate, but from potential creditors and, in some cases, to protect a beneficiary's inheritance from divorce. If protecting your family's inheritance is important to you, then it's worth having a conversation with an experienced estate planning attorney before the inheritance is received. Planning ahead is always much more effective than trying to fix things after the fact. Thank you for joining me today. I invite you to subscribe to my channel, where my goal is to help make these complex items much more easier to understand, because your money always matters.